Okay, let's dive right into this. Today's explainer starts with a gripping true crime scenario that completely spirals into one of the most fascinating and, frankly, most difficult legal puzzles you could possibly imagine. Just picture this for a second. An off-duty police officer, completely out of uniform, commits a horrific crime in the dead of night. Now, obviously, the officer gets criminally prosecuted, right? But what about the victim? What about their lifelong medical bills? Does the state, meaning, the taxpayer, have to pay for the massive damage caused by a cop who wasn't even on the clock? Well, today we're going to unpack a landmark 2006 case from the Constitutional Court of South Africa that tackled exactly this dilemma. It really forces us to ask this tough, central question. When an off-duty cop goes rogue, who is actually to blame financially? It's a classic dilemma. On one hand, you absolutely want victims of state employees to be compensated. But on the other hand, should an employer, even if that employer is the government, really have to foot the bill for an employee who has entirely abandoned their job and isn't even working at the time? To understand how the highest court answered this, we really need to go back and look at the tragic events that sparked the whole thing. Section 1. The Jacaranda Street Shooting. Okay, so the night of October 14th, 1995 in East River, South Africa was just pure chaos. This totally abstract legal doctrine we're talking about. It was born from a very real, very tragic human catastrophe. Let's just map out the timeline of what happened on that street. First, Mr. Allister Roy Luiters is walking with two women late at night. Out of nowhere, shots are fired from behind. Mr. Luiters runs, but he's hit in the neck and the leg, and he falls motionless into the street. The tragic reality is that he is rendered tetraplegic. Second, a man named William David Say happens to be driving by with two friends. They see Luiters lying in the street and immediately pull over to help. Third, they're instantly confronted by this nervous, bewildered man in plainclothes waving a firearm. This man is Constable Lionel Siljeur. He points his gun directly at David Say. Now, David Say spends several incredibly tense minutes just trying to calm him down until Siljeur finally lowers the weapon. But then, finally, when David Say's passengers step out to help the paralyzed Mr. Luiters, Siljeur just unexpectedly opens fire on them from behind. They return fire, and Siljeur totally vanishes into the night. Get this, the aftermath of that timeline is absolutely crucial to the legal battle that followed. Constable Siljeur literally fled what witnesses called the danger zone and just disappeared. Now, police regulations strictly dictate that an officer must report discharging a firearm immediately. Obviously, Siljeur failed to do this. When a captain finally tracked him down at a house the very next day, Siljeur straight up denied being a policeman. He even denied having a service revolver before he finally gave in and pulled it out of a cupboard. For his actions that night, he was criminally convicted on 8 counts of attempted murder and sentenced to an effective 11 years in prison. So, the criminal accountability? That was settled. But the financial accountability? That was just getting started. Moving on to Section 2, who pays for the damage? So, with Siljeur behind bars, Mr. Luiters, who is now tetraplegic and facing just insurmountable medical needs, files a civil lawsuit. And he isn't just suing the man who shot him, he's actually suing the Minister of Safety and Security. His argument? Because Siljeur was a police officer, the state must pay. To understand how this even works, we need to quickly look at this legal concept, vicarious liability. Basically, it's the doctrine where an employer is held responsible for the wrongful acts of an employee, provided those acts happen within the course of their employment. Think of it like this. If a delivery driver crashes a company truck while actively making a delivery, the company pays. But if that same driver steals the truck on a Sunday to go joyriding and crashes it, the company usually doesn't pay because the driver totally deviated from their job. So how on earth does this apply to an off-duty cop shooting innocent people? Section 3, the vicarious liability test. All right, let's move to the next part and see how this builds, because here is where things get kind of intricate. The Constitutional Court actually uses a really specific framework for these exact types of deviation cases. Situations where employees stray way off their mandated duties. They call it the K-test, named after a previous landmark ruling. And there are essentially 2 hurdles a victim has to clear to get compensation. Step 1 is the subjective question. Basically, what was going on in the employee's head? Did they act solely for their own personal reasons, or did they subjectively intend to do their job? Then, step 2 is the objective question. Regardless of what they were thinking, is there a sufficiently close link in reality between their actions and the employer's business? It's this fascinating mix of raw facts and broader legal policy. Now, applying that first step to Constable Siljeur, we have to look at his state of mind. Remember when Mr. David C. was calming him down in the street? Siljeur didn't just stand there silently. He explicitly stated he was looking for people who had robbed him. He actually asked if they had seen the robbers. Mr. Davidsey even noticed Siljeur was carrying a very specific type of pistol that's only issued to police officers, and inferred Siljeur was actively trying to make an arrest. So, the courts looked at this and determined that even though Siljeur was technically off-duty and out of uniform, by actively hunting for suspects with his state-issued service weapon, he had subjectively placed himself on duty. In his own mind, he was acting as a cop.
Section 4. The Minister's Defense. But, the state fought back, and the Minister of Safety and Security's legal team brought a really compelling counter-argument to the Constitutional Court. They basically said, wait a minute, we shouldn't be on the hook for this. Their entire argument hinged on one word: control. When a police officer is on duty, the state exercises direct, hands-on control over them, right? They have supervisors, they wear a uniform, they have a set patrol route. But when a cop is off duty, the state exercises zero direct control. They are completely on their own time. The minister argued it is just fundamentally unfair to hold the state financially liable for the totally erratic, uncontrollable actions of an off-duty employee, even if that employee suddenly decides in their own head to play cop for the night.
So the minister makes this very specific plea to the court. They essentially asked the court to change the K-test specifically for off-duty officers. They argued that subjective intent, just having the cop think they are on duty, really shouldn't be enough. The minister wanted an extra layer added, requiring a clear, objective link to state interests. Their point was taxpayers shouldn't have to pay for rogue off-duty shooting sprees that absolutely do not serve the state in any way, shape, or form. Section 5. The final legal verdict. So, Chief Justice Lange and the Constitutional Court had a massive job here. They had to weigh the protection of the public purse against the rights of a totally paralyzed citizen. And the court handed down a unanimous, resounding decision. First, they affirmed that Siljeur did subjectively act as a policeman. By seeking to apprehend robbers and wielding his police-issued gun, he was exercising police authority. Second, they firmly rejected the minister's request to change the test. And third, and this is huge, they established a really powerful rule. Once off-duty police officers put themselves on duty, which they are actually legally empowered and required to do when a crime occurs, they are in exactly the same legal position as on-duty officers, meaning the state is liable. So the crucial point here, the real so what of it all, is the underlying policy rationale. Why did the court rule this way? Well, Chief Justice Lange pointed out that if you change the rules so that the more outrageous and improper the off-duty cop's conduct is, the less likely the state is held liable, you literally create a terrible backwards system. Shielding the state would reduce the incentive to properly train and carefully screen police officers. By holding the minister completely accountable for the service weapons they issue and the people they hire, the law forces the state to make absolutely sure they don't employ rogue elements in the first place. Finally, Section 6. The cost of delayed justice. Now, while this is undeniably a massive victory for constitutional accountability, there is a deeply sobering reality to this story. As much as we love the intellectual exercise of constitutional law, we really can't forget the human being at the center of all this paperwork. 11. Just let that number sink in for a second. 11 is the number of years Mr. Luiters had to wait. From the moment he was shot on Jacaranda Street in 1995, left paralyzed and requiring immense medical care, to the day this final judgment was handed down in 2006. 11 years passed. For over a decade, while lawyers debated subjective intent and vicarious liability in comfortable, air-conditioned courtrooms, a tetraplegic man did not receive a single cent of compensation. The early period of his rehabilitation, when financial support was most desperately needed, was spent just waiting on a slowly churning legal system. Which leaves us with this final, genuinely provocative thought, one that even the Chief Justice highlighted with deep concern in his ruling. When justice takes more than a decade to arrive, especially for someone severely disabled by a catastrophe, is it actually still justice? The law in this area has to function to promote justice practically, not just theoretically on paper. While this ruling absolutely ensures future victims won't be left abandoned by the state, Mr. Luiters' decade-long wait really challenges us to look closely at the speed of our systems. I mean, what good is a perfect legal doctrine if it arrives 11 years too late? Think about that and keep questioning how our systems actually serve the people they are built to protect.